makes more fun. All right, welcome to Contract Wednesday. We're actually going to do some seller carried financing documents and forms, which you don't come across very often, and so we're actually going to also help you find them. So think of it this way. Anytime you write an offer where you represent a buyer and the buyer wants to not only buy a piece of property, but they're hoping that the seller will carry the paper, which basically means the seller's the lender, you're going to include in your offer a Form 22C, which there's a separate video on, and you should watch it because it's awesome. All my videos are awesome. Right, Donald? Mm-hmm. Totally. But it walks through carefully how to fill this thing out. But you'll notice under the promissory note and deed of trust that it specifically references LPB forms. LPB forms are limited practice board forms. So these were drafted by attorneys knowing that they would be used by us, because what a lot of agents don't realize is we have a form of an attorney's license. It's a very, very limited form, but we have the authority to fill in real estate contracts. That's why escrow officers also have, you've seen them referred to as limited practicing officers, LPOs. Same thing. They have a limited license to complete forms that are typically prepared by attorneys. So what Form 22C does is it says, hey, buyer and seller are agreeing to this deal where the seller's going to carry paper and it's going to be secured by a promissory note and deed of trust. Is the most common way you're going to fill this form out. Again, watch that video if you want to know what the other alternative ways are. And in that paragraph, it says the promissory note, we're going to use closing LPB Form 28A. And the deed of trust, we're going to use LPB Form 22 or 22A, depending on whether you want a due on sale clause. Well, where the heck do you find those? Because if you go into express forms, you won't see a 28A. Right? I'm in the all file, right? Form 28 is a condo purchase and sale agreement. This is not the place to go find these. You scroll back up here to the top and you will see groupings of documents here on the left. And one of them is called LPB forms. So if I click on that, it's going to take me to a page that says LPB forms are available through the Washington State Bar Association website. So I click on that link, it takes me to the Washington State Bar Association site, and there's a bunch of limited practicing officer forms, and I can scroll down and find 28A promissory note. And then they provide both a Word and PDF file. Now, I'll warn you right now, these files are not nearly as easy to fill out as the MLS forms, because as you probably noticed, the MLS forms are PDF files that have fields in them that you just fill out the fields and it doesn't mess up the formatting or anything. You just tab from field to field. They're very slick and easy to use. Then you save them. PDF file, if you download that, it looks like, I think I opened it. No, maybe I didn't. It just looks like a regular PDF. It has no fields. It's not editable. You would just print it and handwrite it. The Word version looks like this, and it too does not have fields. So if I want to make a promissory note for $500,000, I have to do that, right? Kind of a pain, right? So these really are more easily done by printing them and handwriting them. So what we're going to do is, for the video, we're just going to go through the areas that you would fill in. I'm not going to type in them. We're just going to talk about them, right? So promissory note has a date. This is the date that you're entering into the agreement to borrow the money, right? So it wouldn't be dated today. It would be dated for the closing date. And the city and state is referring to when it or where you entered into the agreement. So the property's in Tukwila, but you might go to an escrow company in Seattle. So you'd fill out Seattle, Washington. Okay. For value received, blank space, hereinafter maker, that's the borrower. That's the term for the buyer who is becoming a borrower by virtue of this promissory note. All right. Promises to pay to holder, that's the lender. And in this context, the seller, because they are becoming a lender by virtue of this closing and this promissory note. All right. At is an address. Where does the holder want payments to be made? So as we were talking about a second ago, if Donald's the seller in this case, he's going to give us a P.O. box or some place for me to mail the payments to. Okay. He also can change that over time just by notifying the borrower, right, or the maker. So if Donald moves, says, hey, I'm not paying for that P.O. box anymore, I want you to mail it here, he has the right to do that. And I agreed in advance to now mail the payments to a new place. The principal sum of blank dollars, right? So in Linda's case, it's 190,000 is the principal sum. That's the amount of the loan, right? I think I put 500 at the top. I'm going to change that to 190 just so it's specific to Linda's situation, right? They're buying a $390,000 property. They're putting 200,000 down. So the principal sum right here would be 190. All right. Then you would type the text version of it here and the numerical version of it here with interest from, this is the close date. So interest is going to start accruing on the day of closing. So in Linda's example, it's the 19th day of October or September, right? 2016 on the unpaid principal at a rate of, this is where you'd put the type version of the rate. This is where you'd put the numerical version of the rate. Make sense? Then we get into paragraph 1, which is the payment amounts. You don't always have principal and interest payments. That's also known as an amortizing payment. Sometimes there's no payments. Sometimes it's interest only. That's to be negotiated. Now, in Linda's case, they agreed on an amortizing payment. So I would literally just put an X there, right? Principal and interest installments of, and in our loose example here, we said it was something like $1,982. So you would do the text version, right? And then over here, you would do the numerical version. Use an amortizing calculator or a mortgage payment website to calculate this because it's not simple math. Or call your loan officer. Or call me. I am a licensed loan officer. All right. So we're going to do principal and interest payments. The installment payment shall begin on, this most commonly is going to be the first day of whatever month follows the closing date by a minimum of 30 days. And I explained it in the other video, so I'll just give you the brief version here, but it always skips the upcoming first of the month because mortgage payments are paid interest in arrears. So if today is September 14th, the first payment is going to be November 1st for Linda's client. Make sense? And then shall continue on the first day of each succeeding calendar month, most likely, right? And then due in full on the first day of November 2019, because in Linda's example, they have 30-year amortization, but a balloon at 3 years. So that's the due date for the full final payment. Then it gets into what happens if you're not paid on time or late. Mortgages have what's called default interest. So if you fall behind, the interest rate goes up. If you represent the buyer, you don't want it to go up very much. If you represent the seller, you want the legal maximum, which in this state, usury laws is what regulates that, and the limit is 18%. So that's why it defaults to the maximum. But that's to be negotiated. So I would start somewhere lower, maybe 10 or 12, something like that. You want it to seem punitive, so the seller agrees to it, but the less punitive, the better, in case your buyer runs into some financial straits, right, where money's tight. Absolutely.
If I write this and then the seller doesn't agree with the term, can you terminate it?
No. Does he? So the question for the video is if Linda prepares this and the seller doesn't agree to it, can he terminate it? No, you would have to have the right to terminate. Just because you don't agree to the terms doesn't mean that gives you the right to terminate, right? Nowhere in the promissory note does it say if seller refuses to sign this, this agreement is terminated. But in your purchase and sale agreement, there's probably language that says both parties agreed to enter into this and their signatures will not be unreasonably withheld. So you're forced to iron it out, right? And remember, it's not yes or no, it's always compromise. Prepayment, maker may prepay all or part of the balance. Currency, all principal and interest to be paid in the lawful money of the United States. Late charges, most mortgages are due on the 1st, late on the 15th, and if they're late, they default to 5% of the payment amount as a penalty. That's typical, so you just have to decide. Due on sale, so you have to decide, are we going to make the deed of trust reflect a due on sale clause? That's to be negotiated. Does your client have any intention of selling it, like during the 3 years? No? So then he probably would be okay with agreeing to a due on sale clause.
Maybe he will, but we haven't discussed this so clearly.
So then if I'm you and I'm preparing these, then I would deliberately choose the deed of trust form 22 that does not have a due on sale clause.
Which form?
22, yeah. The LPB Form 22 is the deed of trust. See right here, LPB Form 22. Now, you may have already checked one of these boxes. You should look at your purchase and sale and see what you agreed to. Okay? So let me get back to here. Acceleration, if you get late, the note can be accelerated. Attorneys and fees, so if the holder has to pursue you or pursue your client to get paid, your client is going to pay for those attorney's fees. Waiver of presentments, maker waives presentment for payment, notice of dishonor, protest, and notice of protest. So those are all provisions about how the money needs to be delivered and what's acceptable. Non-waiver, no failure or delay by holder in exercising holder's rights under this note shall be a waiver of such rights. So just because they didn't issue a notice of default immediately doesn't mean they can't, right? Severability, integration, conflicting terms, execution, commercial property. Maker represents and warrants to holder that the sums represented by this note are not being used for business, investment, or commercial purposes and not for personal, family, or household purposes. So this says not applicable unless initialed. So you would leave that blank, right? Oral agreements are non-binding. Definitions. The word maker shall be construed interchangeably with the words borrower, payer, and the word holder shall be construed interchangeably with the words lender and payee. In this note, singular and plural words shall be construed interchangeably. So that's just a typical attorney language to clean up anywhere where they didn't use the proper phrase. Additional terms, we talked about that in the other video. If you had some agreement that a lump sum would be made over a period of time or something like that, then you could attach an Exhibit A and spell that out. This notice is secured by deed of trust, right? Then they execute it, and that's it. And I think I missed the address piece at the end. Maker's address for all notices. So this could be the subject address, right? Because the maker is the borrower. And if he's living there, then that's where they could reach him by mail. Any questions on this one before I shut off the recording? Pretty straightforward. You guys are getting tired of all these payments and amortizations and all that.